Good morning, ladies and gentlemen. This is Kelly Runner-Singer, Senior Program Attorney over at the National Council. I'm also with the National Judicial Institute on Domestic Violence, and we have a wonderful webinar set up for you today. I'd like to introduce two of our amazing presenters. Oh, Danielle Pumarki, my program manager, just walked into the room. But I'd also like to introduce our two wonderful faculty today. We have Judge Elizabeth Berns, who's one of our senior NJIDV faculty from King County Superior Court in Washington. And we also have Professor Todd Brower from the Williams Institute, which is one of the premier judicial training programs out of UCLA in California. So we're very excited to hear them both today. Now, the one thing I'd also like you to know is that this is a two-part webinar series. This webinar is going to be on what judges need to know about domestic violence in the LGBTQ community. And on June 1st, we also are going to have a webinar on domestic violence in the transgender community with another one of our faculty, Judge Victoria Kolakowski out of Alameda County. So very exciting things. So with that, I'd like to turn it over to Judge Elizabeth Berns, and take it away.
Thank you, and good morning if you're on the West Coast, and good afternoon if you're Midwest and East Coast. Thank you all, and welcome to the webcast we have this afternoon. I want to start out by just letting you know how we're going to organize our presentation, and then I'm going to go through some learning objectives and get started with our content. We're going to organize this session as follows. So for the first few minutes, I'm going to talk a little bit about language and barriers, and then Professor Brower is going to talk about some demographics, after which time we will take some questions on that first section, so that if you have questions as you go along, we'll certainly give you an opportunity after the first two sessions to ask those questions, and we'll do our best to answer the questions. After that short question session, I'm going to talk a little bit about tactics, and Professor Brower and I are also going to then talk about court intervention and response, after which time we'll also have a question session, and then finish up afterwards with time permitting with some final thoughts to share with all of you. Our learning objectives for our webinar this afternoon are as follows. We're hoping that you're going to be able to recognize the importance of language when working with the LGBTQ populations in your community and in your courts, identify current demographic data for LGBTQ populations and the prevalence of domestic violence in LGBTQ populations, analyze tactics used by abusers in LGBTQ relationships, and discuss the methods to improve the court response to LGBTQ domestic violence. As a starting place, I'd like to talk a little bit about language. It's a ground that we all need to start from and have in common. Many of you have heard the acronyms LGBT. Probably in the last couple of years you've started to hear LGBTQ, and now we're even starting to hear LGBTQA. And so as the acronym grows, so must our understanding of what all that means. So what I've done is just broken this down very simply into a general representation of what each of those letters and words mean. As you'll learn as we go through this presentation, everything's on a spectrum. And so even the language that people use to identify themselves, and certainly the language that we choose to use in our courts, has a lot of power around it. L for lesbian, G for gay, B for bisexual, T for transgender, and Q can mean all sorts of different things, but the most common is questioning, queer, or genderqueer. And I think when you hear the term queer, a lot of people sort of have a negative response or a concerning response because that word in and of itself has typically conveyed a negative connotation, or has a negative connotation. And from the perspective of the LGBTQ community, the term queer is an endearing term. It's a power term. And so you're going to be given the opportunity to kind of stretch your perspective and your awareness accordingly. When we look at the use of language, we also have to consider norms. And so I'm going to go through just a couple of terms here. Some of those terms you're going to actually see in the course of litigation that unfolds in front of you, and some of the terms you won't see, but you need to be aware of these terms if you're to be aware of the LGBT community within which you most likely live to a certain degree. Sex assignment, simply the gender that you're assigned at birth, and it doesn't always coincide with your preferred gender. A legal or gender marker is the M and the F that are designated on legal documents. There isn't another option to date on that, but that's what that means. Gender identity and gender expression. These are two terms that most commonly go together. How we identify ourselves may or may not coincide with how we express ourselves. And we'll talk a little bit about that as we go through our presentation, keeping in mind that really we're talking about a spectrum here. The next term, sexual orientation, are females oriented more towards females or males, and vice versa. Does someone have a sexual orientation, or is it a broad orientation? That's a term that will come up, and one that we've had around for a long time. It can frequently be misused. Homophobia or transphobia, basically these are systems or attitudes or biases of discrimination in favor of one sex or gender or the other. So when it comes to, and actually I've jumped ahead in terms of heterosexism, homophobia and transphobia are the fear or hatred of gender non-conforming behavior. And then heterosexism is that system or attitudes or bias that really comes from that fear base, giving the opposite sex sexuality in relationships some kind of a priority. In other words, only opposite sex sexuality and relationships are the norm, and therefore they're superior. And that's what heterosexism refers to. So as I mentioned, even these terms don't really capture all our expressions or our identity of sexual orientation. If you think about it as a spectrum, I like to think about it as a color spectrum. We all fit somewhere on that spectrum. Every human being on the planet is somewhere on that spectrum. And really, our perception of the individuals that may come into our court is based on where we put them on that spectrum. Just to hold the concept and be mindful of that spectrum is going to give you an advantage over many others who have closed down. So as you look at the language that we've gone through and some of the language that you may be aware of yourself, consider how you might be addressing or identifying someone that comes into your courtroom. Are you listening carefully to how people are identifying themselves? Are you being very generic in how you may identify someone without more specific information? And are you asking in a manner that's appropriate and sensitive so that you can get that important information? Keeping in mind always that we have open courts and we have open proceedings. So the court, in any event, shouldn't be the entity, and you shouldn't be the person that's ultimately outing someone if they're not out, identifying someone if they're not ready to be identified. Language, titles, names, It's all meant to be affirming. We know that in our own professions, and we know that in our own lives. It should not be used to shame others or to make someone feel less than they truly are. So how does this play out? I think here it's important to look at some myths and stereotypes and system barriers. We're getting a lot of our information across the cultures and in the world through pop culture and how that culture depicts LGBT populations. Are they of a certain class? What are their behaviors like? What do they do with their time? And really, ultimately, how are they involved with domestic violence? Nearly 6 million children have an LGBTQ parent, and that is something that Professor Brower will get into with some numbers a little bit later. So this is what we see out in the media and in pop culture, but is it really a true reflection of the LGBTQ community? It's not. I would submit LGBTQ individuals can be disabled, they can be impoverished, ethnically diverse, immigrants, refugees, elderly, urban, and so on and so forth. I'm going to quickly move through some of these numbers here. You'll have them on your in your materials. And this is just to show you in 2012 where some of the numbers are across the country. And I'll just put in a plug here for the Williams Institute, and Professor Brower can speak more to this, but it was really only until about 2012 that we were able to start collecting information about our LGBTQ populations across the country. And that has a lot to do with people's willingness to self-identify. And consequently, there are limitations to our numbers, but at least it gives us a starting point. So you can see here that there's a significant percentage of LGBTQ individuals that are involved with violence, that are victims of violence. A startling statistic and number still today is that 40% of our homeless youth identify as LGBTQ, and that's a national statistic. There are external barriers and there are internal barriers that impact an LGBTQ individual's ability to come forward and address domestic violence that they may be experiencing. And these external barriers, we've talked a little bit about how people identify, whether they're seen or they're not seen, whether they wish to be seen or not seen. And the internal barriers have to do with their own personal process and their own journey in coming out and the messages that they're receiving along the way. The fact of the matter is that it really does require us to open our eyes, to open our minds, and to open our hearts.
Thank you, Judge Berns. So this is Todd Brower from the Williams Institute, and thanks for the plug for the Williams Institute. What I'd like to talk a little bit about is sort of the demographics. But before we do, I'd like to transition. We were talking about barriers. So one of the things that's true is that there are not only barriers that exist to people's accessing courts and to accessing the justice system in general in terms of being LGBT, but it also interacts with various other populations that an individual might be part of, so that people of color not only experience prejudice or maybe racism in the outside world, but they also this can exist within the LGBT community. What these things mean is that each time we increase this, it increases the isolation that they may feel from other populations. And that we have, for example, when we add these things in, race, gender, age, etc., that the communities that one would expect might support a survivor of domestic violence may not actually be there for this particular individual because of racism or sexism or ageism. And so this increased exclusion or isolation from their own communities as well as from resources that those communities might be able to give increase sort of the isolation that sometimes happens when people then don't feel like they should be reporting this stuff, or they can't report it, or the courts aren't open to them. So let me talk a little bit about demographics, so who's there, and more particularly who's in your courtroom, right? So we know from looking at census data, and this is census data that I'm going to be talking about here, that there are somewhere between 9 to 26 million LGBT Americans. So that's a huge spread, and it's because the truth is it depends on what you're actually measuring. If you take a look at this bar chart and you look at the outside bars, they're about identity, LGBT identity. And those numbers, if we're talking about people who identify as a part of that community, are pretty stable. That is to say, it's somewhere between 3 and 4%, and no matter how we cut this data, that's actually sort of the figure that comes up. But if you look at the two middle bars, the second one is any same-sex behavior, people who've engaged in any same-sex behavior, or people who have any sort of same-sex attraction, whether or not they engage in those behaviors. That's considerably higher. And that this pattern is then something that we can pay attention to. Now, as a judge or someone who works in the courts, effectively, I think it's the identity question, which is the usual one when we're talking about domestic violence, because that's what has sort of the trailing impacts on how people behave. So we can see, by the way, that it's not an either or, black or white kind of situation, that these identities and behaviors and culture intermix. And in fact, I've given you data here that a significant number of adult men and adult women have had some same-sex experience. And in fact, the opposite is also true. People who identify as gay or lesbian or bisexual, certainly bisexual, but gay or lesbian, have also had opposite-sex sexual partners. And that, when we get to the statistics about DV prevalence, the bisexual number is actually an important one. The sort of bottom line is, when you have someone in your courtroom, be it man or woman, you don't actually know much about their sexual orientation, and that you can't sort of assume that if they tell you, oh, I'm a lesbian, that means that they've not had any opposite-sex sexual partners and vice versa. So let's talk about where. So in your courtroom, what are you likely to see? So from the census data, we can tell that virtually all of them, 93% of U.S. counties, have at least one same-sex couple. And when you look at this map, some of it is what you would expect. So the dark concentrations are higher concentrations, proportion of people who are same-sex couples. And you see the Northeast or the West Coast and sort of places that you might expect, major metropolitan areas. There are two important things about this for thinking about domestic violence and who's in your courtroom. One is even the lightest shades have people who are same-sex couples. Two, the census doesn't actually ask sexual orientation questions. We can tell that this is a same-sex couple because we can read their answers. Married, people who identified a same-sex person as married or unmarried partner were counted, but people who identified as roommates or other were not counted in this figure. But of course, single people are not counted at all. So that these maps understate that. The other thing is, by the way, you don't have to squint and try and figure out where are you in your state and where is your court. If you go to the Williams Institute website, which you can do by Googling Williams Institute, UCLA, or even Googling my name, Todd Brower, you will see a link to the Williams Institute. And the Williams Institute has data on each individual state. So if you're curious as to what's going on in your state, you can find that information. So we can see through this data that the large states obviously have, high population states have higher proportions of people who are LGBT. That's not a surprise in one sense. What is something that we need to think about is that the map that we were talking about, this one right here, it essentially tells you that LGBT people live in urban areas. That's true for same-sex female couples. they tend to live in more suburban or rural areas. So if you're a judge in a more suburban or rural area, it is likely that you have same-sex female couples in your jurisdiction, even if you don't think of yourself as living in an area in which there are a lot of gay or lesbian people. So let's turn to what we know data-wise about the prevalence of DV in LGBT relationships. So to a large degree, the answer is effectively it's the same. That is to say, the prevalence of domestic violence in LGBT relationships is more or less comparable to that in heterosexual relationships, about a quarter to a third. And therefore, it's not true that intimate partner violence doesn't happen in these relationships. In fact, it does. And in fact, the perpetrators or abusers are roughly comparable in terms of their dangerousness as we would have in an opposite-sex domestic violence situation. That said, not everything is the same, obviously. Do you see a blank page, by the way? Yeah, there we go. All right, so if we look at the prevalence of rape or physical violence or stalking by an intimate partner, we see a couple things. If you look at women, we see that lesbians and bisexual intimate partner relationships are higher than heterosexuals, and that bisexuals, if we look at men, are higher than either gay people or heterosexuals. That plays into what we know about the data, right? So if we look at where women live, where same-sex female couples live, as I said, they're not always in the urban areas where we sometimes see a higher proportion of gay men. They are in those rural or suburban areas. So if you're a judge in one of those jurisdictions, this is important to you. And then also, if you think about the bisexual stuff, this has importance when we're going to talk about tactics of abuse and other kinds of things, that there may be a greater proportion of people who identify as bisexual that have this violence perpetrated against them. And so that has relevance to thinking about when you see people in front of you in your courtroom, what kinds of questions should you be asking, what kinds of concerns should you have. All right, so before we get to tactics of abuse, we wanted to give you time to ask questions if, in fact, you have them now. Otherwise, there will be another time to ask questions.
So folks, this is Kelly Runner-Singer from the National Council. If you have any questions for our two faculty members, please feel free to type it into the box and we can restate it on the air.
And if not, we'll continue. But
yeah.
I do wanted to make sure that this is a lot of data thrown at you all at once, that you have the opportunity to ask questions. Okay, why don't we continue then? So tactics of abuse.
Excellent. I'm happy to talk about that. And just as a point of transition, now that we know that the prevalence of domestic violence in LGBTQ relationships is comparable to that in heterosexual relationships, I think it's important for us to contemplate whether or not the tactics of abuse are comparable. And the short answer is yes, they're comparable, and then there are some very special tactics that can come into play in an LGBTQ relationship. So you don't need to set aside all that you know about tactics and power and control regarding abuse. You just need to enhance your understanding and how it might apply to this population. Here we are with our power and control wheel, and I love this version which sort of superimposes the LGBTQ tactics within a concept and within a tool that we've been using for some time. And you'll really need to spend just a little bit of time reading this. I'm not going to go through everything that's on this slide, but just to show you, kind of gets into the heterosexism, homophobia, biphobia, transphobia that we spoke about initially, and then really gives you some specific examples of how this may play out in an LGBTQ relationship. The special tactics, and I don't call them special in an endearing manner, but the very unique tactics that can come into play in LGBTQ relationships that don't at all come into play in heterosexual relationships are as follows, and these are the highlights. There's all sorts of different versions of these, but we start out by a tactic which exploits the system of same-sex violence, and someone who has more knowledge about myths and the lack of knowledge of a partner can really take advantage of the other in this regard. Threatening to out a survivor of LGBTQ is a huge tactic. It's very, very common. It's probably at the top of the list when it comes to fear, and it really prevents individuals from making a phone call to report the violence or calling for assistance from law enforcement, all the way to disabling a person emotionally and sometimes physically from getting to the court to ask for relief. Once they come forward, they ultimately out themselves because they have to speak to the violence in that relationship and then face a lot of the bias, stereotype, and generalizations that are alive and well in our community. Similarly, threatening to out a survivor to police, child protection, other authorities. Huge fear in LGBTQ relationships where children are involved is that the children will be taken away. No matter what our laws are doing across the state to ensure that this doesn't happen, the fear is sometimes insurmountable for individuals. Threatening to deny or contact custody to non-biological parents where a survivor has no custody rights. Again, this comes into play. It's a new way of using children to control and influence the behavior and feelings of another individual. More tactics, exploiting power differentials such as race, citizenship, age, disabilities, and the intersecting system barriers that Professor Brower spoke about. There we go. Using sexual orientation or gender identity to isolate a survivor from family or community or organizations and other support networks. Losing your job, having your housing jeopardized in some manner or another, even being excommunicated from your community that may have not known that you were out or in a same-sex relationship or in an LGBTQ relationship. Very violent, sexually violent tactics involve forcing sex to prove that a survivor is a true LGBTQ person. If you're really gay, then this is what you're going to do. Conversely, forcing sex to prove that a survivor is not a true LGBTQ person. And that's extremely powerful and extremely violent and traumatic. Hiding or destroying hormones or other gender-affirming personal items. This is equally as traumatizing and violent for anyone who's transitioning, not being able to have their daily regimen of support can have a significant impact on their health and well-being. Accusing a survivor of mutual abuse. This is a tactic that guaranteed it's the first card that will come out of someone's pocket, whether they're in your courtroom or they're being met by responding law enforcement. And then saying that all LGBTQ relationships are like this, especially for individuals in first relationships, basically saying, again, taking advantage of a knowledge base of someone who perhaps is just coming out, who hasn't had a relationship, they don't know what that healthy relationship is, and someone is saying it's always like this. LGBTQ relationships always involve violence and abuse and control.
So before we get to court intervention and response, which I'm going to take next, there was a question that came up, and it just fell under the outside of the wire. But I want to make sure we talk about it. So the question by Tora Watson is the following. The question is, does intersex and androgynous fall into queer? And the answer is, I guess, maybe. In other words, first of all, LGBTQ, right? The T is talking about transgender, and within transgender, that sometimes in common sort of parlance covers people who are not gender binary, in other words, man or woman, and intersex, someone who is born with genitalia of both sexes, could fall into that, but it's really different in that sense, and so I guess it could fall into queer. And androgynous is a related issue about not gender identity as much as gender presentation. In other words, you might be a man who believes that in fact that's the correct gender for them, that they're a man, but you may present in terms of your clothing or behavior or mannerisms in a not stereotypically male presentation. Or for that matter, you could be a woman who believes, of course, that she is a woman, but she may present in terms of her behavior or clothing or voice timbre or whatever it happens to be in ways that are not stereotypically feminine. And that dimension can coincide with, for example, sexual orientation, but it's different. It doesn't necessarily coincide. And it can correspond to people who are questioning whether or not their gender identity is appropriate. But once again, it doesn't have to. It's a separate dimension. So we can call it part of the queer, which covers sort of the non-traditional aspects. But they're really two different dimensions in that sense. So I hope that is helpful. All right, so now that we've been talking about sort of what the tactics are and these other kinds of things, I'd like to turn to sort of what you can do as a judge or what the court can do and sort of how to do it, because the sort of practical is important. So when we're thinking about domestic violence in the courtroom, one of the things that Judge Berns mentioned is that there's an idea that in fact there's equal abuse. And in fact, that sort of falls within sort of a common sort of stereotype or way of thinking about things, that because you have two people of the same sex in front of you in these situations, that they are, for example, of the same sort of strength or the same ability to protect themselves, or that they're basically equal in that sense, and therefore the abuse is probably equal. The truth is that's a gross oversimplification. The violence is not, in fact, mutual most of the time. And in fact, one of the issues then is if one of the parties has demonstrated a pattern of abusive behavior, particularly to maintain power and control, that's a very different kind of violence or physical behavior than, for example, if you have a survivor or a victim of abuse that uses violence for self-defense, or what we think of as sort of reactive violence. The two are different, and the fact that violence is there and people are of the same sex can sometimes lump everything together that it's equal. But the truth is, of course, you need to look a little closer at that. And when you look closer at it, I think you can avoid some of these things that could happen. Because not looking at that means that you can have these sort of consequences, sort of dual arrests or mutual arrests and cross-protection orders, and those things can lead to then loss of employment or public benefits. And so over the long term, that ultimately leads to a belief that going to the legal system simply doesn't deal with these issues very well, that it can't help, that in fact it makes things worse, and that in fact it's not a place that a victim of domestic violence can go to. That's important because one of the things that we know that data-wise is that LGBTQ people, similar to other minorities, racial or ethnic minorities, for example, in general, have a view of the courts that is less favorable than whites, and that stems from those kinds of minority stress issues and feeling like the court system just doesn't quite get it, so that these consequences for DV cases can reinforce that if we're not careful. So then the issue is, what can we do about it? Well, in terms of thinking about making the courts more welcoming or increasing access, if possible, and it may not be possible in your jurisdiction, one of the things is trying to help people not have to out themselves, so that some states, for example, domestic violence covers situations of any adult living in the home, and therefore a victim might be able to check a box called roommate and not have to reveal that they're in a same-sex relationship. That helps prevent the sort of forced outing, which can be used as a tactic of abuse by an abuser, but also is one of the things that stops people sometimes from entering the legal system. The other thing, by the way, and judges are generally pretty good at dealing with sort of surprises in their courtroom, but you have a female victim and then you have a female abuser, and while a judge may be able to keep things under control, the court staff may have a harder time with these things. And so it's really important you as a judge are responsible for everything that goes on in your courtroom, and that we need to train personnel as to how to help dismantle those barriers for access for people, particularly in domestic violence situations. So then, what can we do? Well, one of the things we can do is to establish and enforce those rules about conduct which is not welcoming, which is offensive, or statements by staff, and particularly by audience members or other people in the courtroom, and to recognize that you yourself and that everybody else in many ways has sort of these stereotypes or ways in which we automatically think about things, the implicit things that form a sort of implicit bias, and that's a natural process. What we need to do then is guard against and minimize the effects of that bias and help others in our court do that as well.
Great, thank you, Professor. What that makes me think about here is that there is a growing commitment across our country to be trauma-informed courts. And this really speaks to being, one element, one factor that goes into being a trauma-informed court, because the inability of a judicial officer or a court staff member or a court in its entirety to acknowledge and respect some of the differences here that we've been speaking about can really lead to a very high likelihood of re-traumatizing someone within an environment that they've come, that they trust, that they're hoping for some justice. And so being trauma-informed includes this information. We have individuals coming in. We know that domestic violence exists in the LGBT community. It is as prevalent as it is in the heterosexual community, so we're obviously going to be facing situations where we're going to be asked to provide for a protection order. And it's not always going to be the case that your standard provisions are going to apply or that they're going to be sufficient to provide the protection that you may deem is appropriate in that circumstance. So in general, keep in mind, you're looking at the behavior of the individuals that are in front of you. And based on that behavior, you are crafting protections that you feel are appropriate, and you're doing your best to avoid unintended consequences. So when we look at provisions and protection orders, they're obviously contact-related provisions, no harassment, no stalking, and you may need to tailor those protections based on the information that you are given, whether it's by affidavit or declaration or testimony, depending on how you run your DVTO hearings in court. Keep in mind the tactics that are used by LGBTQ abusers. So be mindful of outing, and again, you don't necessarily want to say you're prohibited from outing, but you might want to say you shall not disclose information about an individual's sexual orientation or gender identity with the intent of harassing, isolating, embarrassing. But be careful even including that kind of language, because in doing so, unless you do so in every protection order, you're already alluding to the fact that you have an LGBTQ couple who may or may not be out. It's a little bit different if they're out or beyond the concern about being outed. Include the posting of pictures, sexually explicit information in your orders. The LGBTQ communities within the larger community in each one of your jurisdictions is a very tight-knit community. So when you look at keeping distance or you look at participation in events, especially if there are children involved, be mindful of the fact that you can't just keep somebody out of a certain place, period. That may be the only place, whether it's a community center, for example. It may be the only place in that community that's LGBTQ, and so you need to be creative in how you're restricting access or trying to prevent contact, whether it's intended or unintended. Just like with heterosexual couples, mutual orders are not entitled FSC protection. They're not favored. It's not something that you certainly want to fall back on in a circumstance where you can't really figure out who the abuser is because you have two individuals who are of the same sex in front of you. Don't default to a mutual order as a result. Get some more information or require that more information come to the court so that you can properly identify the behavior. Mutual orders, again, they're very, very problematic in LGBTQ context because the enforcement of those is obviously challenging for law enforcement. Violation of those is challenging, and it really perpetuates a very unfortunate stereotype and bias that's out there. So do your best to identify the unique protections that you need to include in the protection order.
Okay, so one of the things I want to talk about are some specific problems and maybe some possible solutions. But before we actually get to this, so I want to recognize, and I think it's important for all of us to recognize, that there's been a tremendous change in the country in terms of both social acceptance of LGBTQ people as well as legal rights. We, of course, now have same-sex marriage, and that changes some of these relationships in terms of their legal standing in the court, but it doesn't change everything in terms of some of these issues, both because it's relatively new and not all same-sex couples have taken advantage of marriage or want to take advantage of marriage, and because it simply isn't always within the sort of bailiwick of what marriage can deal with. That said, there are some issues which judges need to be paying attention to in particular areas. So we can look, for example, at economic issues for these orders. The problem is that some of these LGBTQ survivors may not have the protections available to heterosexual married survivors. Some are, obviously the ones who are married, but there's a significant number of people who are in same-sex relationships in which marriage is not, in fact, part of that relationship. And in those situations, you might consider whether or not there ought to be provisions granting economic relief as part of these orders in order to keep stability, in order to sort of not re-injure the victim or survivor of domestic violence. Similarly with housing relief, marriage, of course, means certain things, but it doesn't always govern property relationships in terms of both leases and estates and land. And therefore, you want to think about whether or not exclusion orders or ordering the abuser to pay rent or utilities as a way of sort of maintaining the status quo and not, as I said, again, economically or housing-wise injuring the party that you're trying to protect. Similarly, think about custody and visitation issues, right? Once again, marriage deals with some of these issues, but it doesn't always govern other kinds of things. And that want to think about whether or not you should have temporary custody provisions within these orders in favor of the survivor, where the survivor in fact has custody rights, biological or adoptive parents, or in those states, for example, that have second parent adoptions, where that's possible. Those kinds of issues are there. And lastly, you might think about whether or not there are other kinds of relief that you might be able to give and that are appropriate and tailored to the LGBT nature of the relationship. And with this, actually, I want to shift gears just slightly. So that's true for your protection orders. But actually, if you think about it, oftentimes one of the things that happens is that people are sent, perpetrators or abusers are sent to treatment programs, etc. Treatment programs are not always all that welcoming to LGBTQ people. And for that matter, the resources battered women's shelters are also similarly not always that welcoming or understanding about the unique natures of LGBT relationships. And so when you're thinking about both in terms of protection orders, but also in terms of sentencing people to treatment programs and things of that nature, you want to think about, is this a program which has the tools to deal with an LGBT person? And not all of them are. And some of them are, for example, 12-step religiously based programs, which may or may not really be appropriate for people in this community, or for that matter, people in the heterosexual community. But it's just something to keep in mind in terms of this stuff.
Super, and just to pick up where Professor Brower left off with the idea that the treatment programs may not be appropriate, just like shelters may not be welcoming. It really depends on your community and the resources that are in your community. Traditional, and I use that term very generally, VIPs are really not set up at all to deal with LGBTQ abusers. And so sending an LGBTQ abuser to a standard VIP program that you have is not going to work, and it's not only not going to work, but it's going to backfire in a very significant way. And here again, you know, your awareness around some stereotyping, some understanding of the tactics, and gender bias issues will really make for better decisions on how to handle treatment. There is treatment available. Certainly it's there, but you really need to become aware of what that is in your community and tap into that. And if you don't have that resource in your community, or you don't have programs that are really starting and set up to address LGBTQ abusers, then reach out certainly to others who do have those resources. Reach out to the NCJ, FCJ, and certainly to us at any time, and we can give you some more information on that. But what happens is that you get this doubled over effect when, for example, you send a gay man into a heterosexual, primarily male battered intervention program. It's really not going to go well, and that individual is not going to get the benefit of the treatment that you're hoping they will. And similarly for females going into intervention programs. As Professor Brower also mentioned about the religious base of a lot of treatment programs, be very careful about that. We still are hearing a lot about conversion therapy across the country. It's not an accepted means of VIP and domestic violence. So I think at this point we want to pause and hopefully address any questions that any of you have on this section or any of our presentations before we conclude with some final thoughts. So certainly like to open it up for some questions.
Right, and I actually see some people are typing, which is terrific, and if we can sort of wait for the typing to happen, that would be terrific. I would appreciate that. So, Kelly, are you going to read the questions to us?
Sure. Professor Brower, we have a question from Mark Skirty. He's indicating he's asking for some help with addressing parties in the courtroom, pronouns, etc. I believe, and Mark, you can correct me if I'm wrong by typing into the chat box that he's asking what's the proper way to address parties in the courtroom if you're unsure of their gender identification.
Right. Yeah, so that's correct. Okay, great. So I think the proper way, and indeed the sort of easiest way, is if you have doubts to simply ask. Dealing with gender presentation or gender identity, and while they're slightly different things, they might present in the courtroom in a way that might confuse people. The question is, how would you like to be addressed and by what pronouns? That, I think, is the simplest way. And this really isn't the time or place to do a whole thing about that. And in fact, there's a thing on transgender issues in domestic violence. But in general, for example, we allow people to present in lots of ways in courtrooms as long as it's consistent with the dignity in court. We should, I think, then, as a rule of thumb, allow people to present in the gender in which they feel most comfortable. And unless there is some issue about identification in which that might confuse people as a legal matter, it seems like the easiest thing to simply ask and to then respect that gender presentation or identity.
So Judge Berns and Professor Brower, we also have a question from Vanessa Hewitt-Quinlan. And she's asking, in jurisdictions where heterosexual BIP programs are the only programs, what are the best alternatives for LGBTQ batterers? And that's a question which NJIDV has had in multiple EJS deployments. Where you only have a BIP program which is catering to heterosexual batterers, what are some alternatives or what are the best alternatives? And could either of you talk a little bit about that?
I can give a few comments on that. Of course, I'm in a jurisdiction in Seattle here where we're fortunate to have programs, but I have addressed circumstances where there haven't been any, and that's reaching out to the community, the professional community. They're more likely than not going to be counselors and professionals that work on an individual basis with these issues as opposed to a full-on BIP program, and it's very possible to enlist the support of those counselors and go through the requirements of a program so that you can you're basically custom tailoring that. So having the support there and trying to tailor it as best you can. I don't think that if there's just zero that the answer is opt out on that, because once again, you want to have some kind of treatment as opposed to nothing at all to deal with it. So counselors in the community as well as the LGBTQ resources in that community. There are LGBT resources and resource centers in almost every community or in a community that's close if you're in a rural area. So I would encourage, and I would actually encourage those of you who are in those jurisdictions to do a little bit of work ahead of time to get yourself educated so that you're not having to do it on the spot now that you have this information.
And Judge Berns, Professor Brower, we also have one other question from Tora Watson, and she's asking, how do you get others to adjust the way they speak? How do you make this environment comfortable for LGBTQ litigants? Because Ms. Watson's saying some are refusing to use the preferred gender pronouns. So how would you do that?
Well, I think in general, right, judges are in control of the courtroom, and in this sense, it's a matter of courtroom control. However you control your courtroom in terms of preventing, let's say, attorneys from making these statements or members of the public from engaging in behavior that you don't tolerate, I think you deal with it in the same way. Judge Berns, perhaps you have some better views from the bench.
I certainly agree with that. And one way to handle that, if you've experienced that or you're anticipating that, is if you have a colloquy that you go through at the beginning of, for example, a DBPO calendar, include in that colloquy some general rules regarding how parties will be addressed. If you feel that there's going to be pronoun issues, you can fall back on a petitioner versus respondent, petitioning party versus responding party. I mean, there's all sorts of options that you can use, and consider including that in your colloquy, and then reinforce that at every moment. So if one person slips, you need to stop and just say, you know, so-and-so, please refer to that individual as responding party, or whatever you've determined and whatever someone's communicated that their preference is. I think this is also particularly important in our juvenile cases, because we're seeing a lot of kids now that are coming forward identifying LGBTQ, but they're not out, and they may be in your court because of the fact that they were kicked out, and so they don't have supporting family members. So be careful on how you're referring to those individuals in light of the fact that, you know, their parents may be present in the courtroom and others may be present. So try to make it as generic as possible, but absolutely keep control.
Okay.
And actually, one last, I just have an add-in, and I will go to the sum up questions. If you make a mistake, by the way, just acknowledge that you made a mistake and move on. It's not the end of the world. People who are transgender or gender disparate are well aware that people make mistakes. You know, you're human, so just acknowledge that.
All right, we got a couple minutes left. We could handle the last few slides.
Yeah, of course. So one of the things that is sort of a bottom line is that a person of any gender or sexual orientation can be abusive, and that when same-sex couples or same-gender couples end up in your court, that you just have to take a look more closely, perhaps, at what's actually going on in that situation. Let's see. So that, as Judge Berns was talking about, the tactics, a lot of tactics are similar, and some tactics are different. There may be other than physical control mechanisms, and that the person who is surviving this abuse might then use defensive physical power as a tactic of survival. Then also, laws protect people from discrimination based on sexual orientation and gender identity. Well, the truth is, of course, that in the majority of the states in this country, that's actually not true. But even where it does happen, those protections don't always prevent abuse, of course, and don't always mean that they're terribly effective for people who are afraid or have these barriers to accessing the legal system and legal remedies.
Great. So keep in mind that traditional safety planning responses don't really work for LGBTQ survivors, and they can lead to further isolation. We talked a little bit about how the LGBT community is a tight-knit community. It can be a small community, and survivors are really in the best position to determine what their safety is. I think we're learning that across the board, but it's even more so the case with LGBTQ populations. Provide ongoing education to all providers on how to support and access justice for LGBTQ people, and that really starts by what you're doing now, is getting yourself educated, increasing your perspective, broadening your understanding and awareness, and then sharing that information with others. Everyone that works in our courtrooms or in our courts are a reflection of who we are as judicial officers and who we are as a community, and you have certainly a stake in that. Build the connections with organizations. I spoke specifically about that with regard to maybe BIP, reach out, know what's available, what's happening, who's addressing it, but also just what resources are out there for LGBTQ individuals. That might be the first time that they've really come out in this very unfortunate circumstance, and those individuals need resources just as much as our heterosexual litigants need those resources. So by doing that, you're communicating your commitment to be mindful, to be responsible, and really ultimately to administer justice in your courts.
So I think as a last word, this is the beginning of education. Obviously, you can't answer all of the questions, and then if you're faced with these issues, you're going to have questions. But one of the things that you'll be getting is a list of resources, and that's terrific, and you should use them, and realize that there are local resources in your community. As Judge Berns said, even small communities usually have an LGBTQ center somewhere within the general area, and utilize those things in advance so you're not caught off guard. So we really appreciate your attending and your questions, and I hope this has been helpful.
Okay. Ladies and gentlemen, thank you so much for attending the webinar. This is Kelly Runnesinger from the National Council. If you are interested in doing a training in your own community or would like to mirror the curriculum in your own community, NCJSCJ is the comprehensive technical assistance provider to judges on domestic violence. That is a fancy way of saying we are a helpline for judges on domestic violence issues, training issues, things like LGBTQ domestic violence, community collaboration. So if you'd like to model this training in your own community, we can provide the curriculum to you and back you up on it. If you're interested in the National Council or the work we do, please feel free to reach out to our webinar specialist. You will be getting a list of resources, and I will be contacting the people who said they were interested in modeling this training or doing an LGBTQ domestic violence training. And please remember, we have our transgender domestic violence webinar on June 1st, and we look forward to seeing everyone there. Thank you so much for attending.
Thank you, everyone.
Thank you.
Oh, and we also will be having a survey sent out to you. If you could complete that, that would be very helpful.